Today, March 31st, 2026, California's legislature just advanced a bill that, given everything we've been covering out of Sacramento this month, is genuinely unexpected. Assembly Bill 2584, the Preemptive Self-Defense Act of 2026, passed its first committee vote on March 24th. The tally was 8-0, unanimous. And what that bill actually does has real implications for anyone in California who might ever find themselves using force to protect their own life or the life of someone they love. This is Thomas Updates, and this one is worth understanding carefully. AB 2584 was introduced on February 20th of this year. Most pro-self-defense bills introduced in Sacramento quietly disappear. They get referred to committee and never come back out. This one kept moving. The version that cleared committee last week is a more focused document than what was originally filed. A lot of the original language was stripped away during the amendment process, but what's left is the part that matters most: civil liability protection for lawful self-defense. And that's where you need to understand what the current law actually does, or more precisely, what it doesn't do. California Civil Code Section 50 already exists. It already says that necessary force may be used to protect oneself, a spouse, a child, a parent, or other family members from wrongful injury. That framework has been there for a long time. What it has never included is any protection against being sued for exercising that right. Right now in California, there is no statutory civil liability shield for a person who defends themselves. None. If a threat forces your hand and you stop it, you can still be dragged into civil court by the person you stopped or by their family. The criminal system might clear you entirely, and you can still lose everything in a civil suit. That is the current legal reality. AB 2584 moves to change that. The bill amends Civil Code 50 by adding a direct prohibition. No civil liability attaches to a person who lawfully resists a public offense, and no cause of action can be brought against them for doing so. That sentence, in the context of California's current legal landscape, is actually significant. If you want these legislative updates as they come on AB 2584 and everything else moving through the courts and state houses this year, subscribe to Thomas Updates. This bill still has a long road ahead, and the coverage will follow it. The bill's protection is not a blanket immunity, and the language makes that clear in two places. The first carve-out is the aggressor exception. If you initiated the confrontation, you cannot claim lawful self-defense to begin with, so that exception changes very little in practical terms. It just makes explicit what was already true. The second is the proportionality requirement. The bill specifies that a person who used force that was not proportional to the reasonably perceived threat does not qualify for the civil liability protection. That phrase, reasonably perceived threat, is where the interpretive friction will always live. Your assessment of what was necessary in the moment and what a civil jury later decides was necessary with the benefit of hindsight and perfect information can land in very different places. The bill's protection applies when the force used was lawful. Lawful self-defense is protected. Force that a court determines went beyond what the situation required is not. That gap between those two determinations is real, and it doesn't disappear just because this bill passes. What the bill does accomplish, even with that caveat, is something that doesn't currently exist: a legal basis to get a civil suit dismissed if the force you used was lawful. That's a meaningful shift. The standard for surviving a civil lawsuit changes. Without this bill, anyone can file, anyone can push litigation, and the cost of defending yourself doesn't end when the criminal case closes. With it, lawful conduct creates a procedural floor. If you've been watching Thomas Updates through March, you already know the pattern that surrounds this bill. We covered SB 948, the one that would replace California's written FSC test with a mandatory 8-hour live fire training course, and that bill is still making its way toward hearing. We broke down AB 1078, the 3 per month cap on firearm and precursor part purchases that just took effect April 1st of this year. And Roe v. Bonta, California's ammunition background check law, went before the full Ninth Circuit and Bank panel in Pasadena on March 25th. I'm not going to walk through any of those again here. If you want the background on any of them, the previous Thomas Updates videos have that covered in full. The reason that context matters for AB 2584 is contrast. Every other piece of California legislation we've tracked this month has added layers of restriction: training hours, purchase caps, background checks for ammunition. AB 2584 is moving in the opposite direction. A unanimous committee vote on a bill that removes a legal liability threat from lawful self-defense in the same state in the same month is a notable development in that broader picture. The vote was 8-0. That reflects either genuine bipartisan support or, at minimum, a committee that saw no reason to object to this version after it was amended. Whether the same dynamics hold through the full legislature is a question this channel will track. A committee vote and a signed law are separated by a significant amount of legislative distance in Sacramento, and California's history with self-defense protective legislation doesn't offer much reassurance that the path forward is smooth. There's also a question the original bill text doesn't answer: what happens when this reaches the governor's desk, assuming it gets there? That conversation connects to reporting Thomas Updates covered earlier this month: the governor's own situation involving a firearm he paid for last year and still has not been able to legally acquire under California's own rules. If you watch that video, you already understand the complexity of that position. Whether it translates into how he would handle AB 2584 is genuinely an open question. What's confirmed as of today is this: the bill cleared its first hurdle. AB 2584 is alive in the California legislature. The Preemptive Self-Defense Act of 2026 is not signed, not law, and not certain to become either, but it passed 8-0. That's a start. As this bill moves or doesn't, Thomas Updates will have the breakdown. If you want to be here when the next vote happens, subscribe now. Especially if you live in California, this is the kind of legislation where a single committee hearing can change the trajectory fast. And before I close this out, what you've just watched is built on publicly available bill text, official California legislative records, and public reporting. This is meant to inform, not to advise. If AB 2584 or any other self-defense law in your state has a direct bearing on a situation you're dealing with, the person to call is a licensed attorney who practices in your jurisdiction, not a YouTube channel. That's not a disclaimer I'm required to give, it's just accurate.